This is Bob Ambrogi, and today on Law Next, we have something special for you. It's a fascinating panel discussion on alternative law firm models. You'll hear from 4 leading experts with very different real-world experiences. We're presenting this special production in association with LexLab at UC Hastings School of Law in San Francisco, where the panel was recorded on April 3rd, 2019. The panel was moderated by Alice Armitage, Director of Applied Innovation at UC Hastings. On the panel were Patrick Pallas of Pallas Law in Tacoma, Washington, Augie Rakow of Atrium LLP, Nick Long, who's the Senior Director of Legal Operations at Reed Smith and also head of its tech subsidiary Gravity Stack, and Samina Cluck, formerly of Thomson Reuters and now with the pro bono platform Paladin. We'll get to today's interview in just a moment, but first, let's hear from the sponsors who generously support Law Next. And now, on to this week's interview.
Grab something to eat and sit down, please. We want to get started. We've got 4 terrific panelists here, and they've all got really fun things to say. By the way, for those of you who don't know me, I'm Alice Armitage. I'm a professor here, the Director of Applied Innovation, and I've spent the last 8-9 months building LexLab. I want to introduce you just briefly to everybody here, and then I'm going to let them each tell you a little bit more about what they're doing in the legal space that's innovative, because that was kind of the criteria for whom we asked to join us today. So first, right here to my right is Augie Rakow. He is a UC Hastings grad. He was an Org partner, spent a lot of years at Org first, and now is one of the co-founders of Atrium, which I will let him tell you about, but is one of the more unusual law firm structures that you will ever see, at least for now. We don't know what's coming next. Next to Augie is Samina Cluck. She's an account executive at Thomson Reuters. She recently left them, and she has an exciting new job, not public yet. Sorry, you can't know what it is, but she is still going to be in the legal tech space and is a thought leader in that area. So next is Nick Long. He is a partner at Reed Smith, and he's on the board of directors of Gravity Stack, which is a tech subsidiary that Reed Smith created and sells and uses technology projects. So he will tell us more about that. And then last but never least is Patrick Pallas of Pallas Law, and he has used technology in many innovative ways to practice law on a small firm model. So I'm going to ask all of them to tell you a little bit more, and then we're going to start asking the hard questions. Augie, we'll let you go first.
Nice to meet everybody. I came to Hastings after being out of school for about 10 years or so. When I was 30, I came back to school here. Started off as a patent litigator, had been a patents translator the last few years leading up to law school. Started as a patent litigator, switched over to doing corporate work about 3 years into my practice. Had always really been focused on trying to develop a book of clients, and actually got my first client while I was still a student here at Hastings, which was awesome. And I've always been really kind of looking for new ways to differentiate and provide kind of interesting solutions to clients. About 2 years ago, after making partner at Org, I'd been a partner for about a year. Met my co-founder, Justin Kahn, who's also very well known for having founded Twitch for the gamers in the audience, or anyone who has kids. And he was very interested in how to really had been puzzled by why law firms didn't behave more like businesses, and his most kind of vendors to company, why law firms didn't act like kind of operate themselves like businesses. And with that insight, we formed Atrium. I'll tell you more about it when we get into things. Atrium is a law firm serving startups, mostly just startups in the Bay Area, but planning to grow to be a large multi-practice law firm. Nice to meet everybody.
Great, thanks. I'm Samina Cluck, as she mentioned, and I clerked for a couple of years for the 8th Circuit. I practiced for exactly 1 year and 9 months, of which 9 months I was looking for another job, after it took me a year to come to terms with the fact that I hated practicing law. And then I was at Thomson Reuters for 16 years. So, being in a Fortune 500 tech company is a really different experience from the startup world. And, I worked with some of the biggest law firms in the world, and they always constantly wanted to co-develop with us or customize what we had put together to fit in their in their workspace and their workflow and their market and their global setup. And it was difficult sometimes at a company that large to just turn that ship around. And so part of my job was just trying to do whatever I could to push the business forward as much as I was pushing my clients forward. And at some point I started, really looking at legal technology, as a way to drive change in the industry. I feel like the legal industry has been a bit immune from a lot of other industries and kind of moving to more of a consumer-driven culture, maybe because lawyers are the artisans, right? I'll pay a lot of money and a lot of time to go to school to be that artisan, to say, I know the best way to handle this, or I have examined everything here and this is how we can do it. So I spent a lot of time writing and tweeting and speaking about emerging technologies and how I think it can change the practice of law. Diversity and inclusion, I think it's a huge thing we're talking about with lawyers, and not as much in a legal tech space, and how important that is for developing technology, that the folks developing it look like the intended constituents. And I've been super excited about schools like UC Hastings and students coming out with a lot of different skills that if I was in law school and I got to learn about design thinking, that would have been super cool, and I would have been branding the heck out of that on social media. So I hope you all are. And I'll just pass it over.
Thanks. Your story about artisans reminded me of something that I think we should come back to, but we were recently talking to one of our partners about the use of technology, and his comment was, I'm a brain surgeon and you guys are the janitors cleaning up the surgery room. So we should come back on that perspective of legal technology. But with that introduction, I'm Nick Long. I was a partner at Reed Smith. I recently changed positions, and I'm now the Senior Director of Legal Operations for Reed Smith and a Director of Gravity Stack. My background is as a corporate partner in the M&A group. I'd been practicing for almost 20 years in M&A, and very little changed in that practice other than the use of virtual data rooms. It was still being practiced the same, and I got kind of bored doing the same thing the same way over and over again, which is what got me interested in the technology initiatives that our firm was working on. We'll get to what Gravity Stack did when we talk about the larger session, but the other thing and the other reason why I love schools like Hastings is I work quite a bit in my role with our knowledge management group, and Reed Smith is unique in that 2 years ago we launched what we call our KM Summer Associate Program, where we're looking for technology, law students who are interested in practicing in a different way, that have a technology background or are interested in how technology can change the legal profession. And in their course of their summers with us, and in their our first student will be starting this fall, they learn about not just being a lawyer, but also different ways to practice technology, use technology in the practice of law, and different ways to develop new technology for the practice of law. So that's a couple of ways we're being innovative. And with that, I'll turn it to Patrick.
Sounds like Reed Smith is another firm where the technology innovation and even legal ops innovation maybe is very closely linked to knowledge management, which is an interesting kind of just historical footnote.
Yeah.
How are you? Yeah, I knew there were voices out there. So I'm sensing from this discussion already that this is going to be in part about our journeys. And I think all of our journeys here are dramatically different. I know that mine sounds nothing like any of yours, and yet here we are at the same table. My journey came from being a solo small practitioner, right, representing injured workers. Along the way, I spent a lot of time volunteering, ended up being the bar president of the state of Washington, so represented 37,000 lawyers in Washington. That put me onto a more national scene of traveling and seeing the law from 10,000 feet. What are the trends going on for the 2/3 of solo and small practitioners? What's happening in big law, right? Where are these things occurring? And so the dynamic in my practice is twofold. One, after seeing all of the changes from this 10,000-foot view, I came back home to my firm and said, what do I need to do to really change this? How do I get ahead as a solo and small practitioner to compete? And so we're working hard to make that transition, to look for a model that maybe it can be the new model for solo and small practitioners, new technology that's not being created for us where we need it, right? And the other side is on the president's side. I'm the National Conference of Bar Presidents. That's presidents from around the country, past presidents, who then help shape policy direction for the rest of the bar, one leader at a time. So from that end, we're saying, how do we need to change the entire practice, the rules of professional conduct, for example, so that the whole practice, the whole profession can move in a way that's innovative and at the same time dovetailing with what I'm doing back in my office. I think our stories are going to be similar but dramatically different. Anyway, I look forward to this conversation with all of you and with all of you.
Hear me on this one? Yeah. Okay. So I'm going to try and keep this moving because we only have an hour and you guys all have really interesting things to say and I know they're going to be great questions. So let me pose this and you guys, I would want this just to be a conversation. So jump in as you feel, inspired to do so. But so what I would like to pose is the first idea I'd like to talk about is the fact that for so many years, perhaps, since the late 1800s, if not before, the idea of a lawyer was someone who was an expert, and people came crawling on their knees begging for that kind of expertise to get them out of trouble, right? And so it was someone, that was revered. And I think that, in my opinion, the whole structure of the business model of law firms came from that idea that we don't have to worry about customers. People will be begging for our services. I think, and if you look at and there were plenty of other industries that did that too for a while, but most of them, I can't think of another one maybe that hasn't come to the realization that the world has changed and maybe that business model doesn't work anymore. So my question to all of you is, what part does technology play in that? What part does the market to customers play in that? And how soon? So at the same time that we see all these forces, technology and market demand and so forth, we hear from certainly the big law firms, well, we're making more money than we've ever made. How can you say we're doing something wrong? So I'd love to hear each of your thoughts on that and how that. You're jumping in.
Conversation with one of my colleagues yesterday. So you're right. I mean, it has been viewed as this sort of lofty ivory tower legal profession, and I was talking with the other director of Gravity Stack the other day, and we were wondering how to get past the partner who thought he was a brain surgeon and the rest of us were just there, wasting his time. And the answer is the profession has changed because his comment was, our clients don't look at us like the revered God on high anymore. We're just vendors. We're a vendor like any other vendor and can be replaced like any other vendor. That bond that used to exist between lawyers and clients has slowly eroded away, especially with larger corporations who submit these RFPs every 2 years and just want to pick someone new, or new, better, faster, cheaper. And that's where technology becomes in, because yes, we made a lot of money last year. A lot of other law firms made a lot of money last year. And we'll probably keep making money for a long time, but clients are driving the need for technology, because when they put out these RFPs, when they go to a law firm who says, yes, I'll charge you X times hours billed, they don't want to hear that. If they say, we'll charge you X times hours billed, but we can do the project this much faster because if we layer in technology, we can save this much time and we can guarantee a much more accurate product. So a lot of that desire is being driven by the clients as we see it.
So, you start with this idea that we were a monopoly. We used to own this space. This was our space. And we're still, luckily, the only profession that is self-regulated, but we're holding on to that by the skin of our teeth. And we're lucky to still be self-regulated. Why are we challenged? We're challenged, I think, because we're not serving the needs of the public, because we don't have the skill set. We're lawyers who practice law. Where are the accountants? Where are the marketing people? Where's everybody else who gives us the tools to run a business that can practically give help to this monstrous latent market that some people say is $300 billion to $1 trillion, that is money left on the table of the people in this country that need our services that we can't get to. So that's the 2 points, right? We need the technology to be able to decrease the cost of law, to bring in experts outside of law into our business models to be able to do that. And we need to be able to take that lower cost version and those marketing skills and be able to then disseminate law to 2/3, some would say, depending on what your income class is, 80% of people don't get served, or if you're in the business class is taken care of. And if you're in a firm who caters to the money and the business class and the big companies, you're making more money than ever else, but we're leaving the rest of the world behind without legal services. Technology.
Small business class too.
Yes,
Yeah,
yes,
small
true.
business class too, for sure.
Fair, yes, fair. So the important part of technology really is continuing on this path of us being a profession and being able to help people, but at the same time realizing that we're no longer a monopoly and we certainly can't do it on our own.
So let me just ask you something and drill down a little on that. So as a small firm practitioner, do you find that your clients put pressure on you in terms of what price they'll pay, or does it come through in the kind of way they want you to deliver the legal services?
Yeah, right. Isn't that the big shift? It's I'm a lawyer, I know what's best for you, and here's the way I practice law. Not anymore. Now it's you're the consumer. How can we be consumer-centric and deliver law in the way that you need it at the cost that you need it, right? That's the big change. And so the pressure that comes from clients are the clients who are ones who are comfortable with Amazon and Uber and Netflix, who are everyday folks with everyday incomes or even maybe poverty who need law. And so they want us to provide it to them in a way like they're getting used to getting it every other business that's out there. And that's where the innovation, the changing of the models, the using of technology really gets interesting in this huge area of opportunity that's opening up for lawyers that never existed when we believed we were the monopoly, you had to come to us, and all we did was practice law.
So I have a really different view on this. I really don't think that technology is important. I really don't think that a lot of this stuff is I think these are all new and increasingly stronger forces acting on the market. But from the perspective of an individual law student or lawyer trying to figure out how do I have a good career as a lawyer, I think that you want to ask yourself, do you want to be an expert, or do you want to be a do you want to be a substantive expert where you have a set of issues that you know better than anybody else in the world, and there may be 5 other people in the world who know that set of issues as well as you do? Do you want to be that kind of an expert, which is a little bit more academic, a little bit more kind of looking at this? I think a lot of the things that maybe originally drew you to law, depending, if you liked doing those LSAT puzzles and you like reading case law, you like that stuff. You probably like thinking about legal issues. You probably like thinking about how legal issues change as kind of the business community or kind of social life changes. And if you can put yourself in a position where what you're trading is your expertise and you're differentiating yourself on your expertise, that's a really wonderful way to be a lawyer. It's really fun. If, however, you're someone who says, I kind of like being around the business stuff. I like that going to law school will give me an opportunity to work on deals where I can kind of be around that stuff. But I don't really actually like the content that much. I just kind of like being around it, and you kind of ask, and that's perfectly fine. And you say, well, maybe I want to focus on kind of the operational aspects of being a lawyer. I want to maybe go start some kind of business that will provide a platform for experts to practice on, or I want to go build some kind of platform where customers can come and kind of self-service to get legal solutions. That's a whole different way of thinking that, and then I think you definitely do want to be focusing on the technology and trends, and you're thinking more as a business person in that case. But if you like thinking about legal issues, and you like when kind of you read like the SCOTUS blog or something, and you like to listen to kind of what's the issue that's going up on appeal. If that's exciting to you, which it very much was for me and still is, then I think what you really want to do is you want to double down on that, and you want to find a way to differentiate yourself as an expert, and you want to be aware of the other stuff. You don't want to be a total Luddite. You want to use email, but it doesn't change that fast. It doesn't change that fast.
Can I challenge that?
Yeah, please.
Okay. Oh, or that one. The thing about being a subject matter expert, at least the kind of trend line we're seeing, is it's important to know the subject matter really well. But if you asked any one of us a specifically substantive question, the answer we would give you would be based on our individual experience. Maybe if you have a really good firm, all of the experience of your firm. But that's a very narrow set of experience, right? If you can use technology to leverage that to find how a particular judge has ruled on a particular issue, how that issue is played out in courts around the country, how academic journals have treated that particular issue. So the more you can leverage technology, the better you can be as a substantive expert, rather than just saying, well, Nick Long said this. Nick Long might not be right all the time, although I think I am.
So just to develop it, if I hear what you're saying is that kind of the position I'm putting up of really differentiate yourself as a substantive expert, and the other stuff will, and the technology stuff will follow. You're saying, well, no, that's sort of a false dichotomy because really you can use the technology to differentiate. Absolutely, yeah, totally. But to me, the key point there, though, is you want to differentiate. You don't. I love this quote. Yeah, you know where I'm going. Competition is for losers. Competition is for losers. If you're competing, you're in some sort of race to the bottom. You want to be different, and it's very easy to differentiate yourself. You've come this far. You're smart. You know how to read and write. You know how to hustle. You know how to work hard. You have a work ethic. Who cares if you're not in the top 10%, 20% of your class, whatever? You're like past that point where that's going to be your big differentiator. You know, if you can find a set of clients, a type of client who you like hanging out with, you want to go to their industry events, you want to go to their cocktail parties, you like talking to them, whether it's athletes or investors or parents fighting over whatever it is. You find kind of a client group that you like hanging around. You read their articles, you get into their stuff, and you make yourself available to them and useful to them. Get smarter and smarter at their set of kinds of things that they need help with, and clients will come to you. And you have to find ways to make yourself available to them. But you need to differentiate yourself. If you're undifferentiated, then you have to compete on stuff like LSAT scores and grades and everything else that everybody else is competing at, and there can really only be one or two people at the top. And it's not a fun way to try to make your career. That's kind of how we got here. That's how you got to law school, was competing on these same ranks, these same kind of ranking systems that everyone else is competing on. But now is a great point in your careers to learn how to shift gears and focus on differentiation. Pay attention to what you enjoy. Pay attention to what type of people you like being around and what kind of people you like helping, what kind of problems you like being known as an expert in. And you can use technology to differentiate, absolutely, both in terms of building up your differentiation. How do I learn about new case law? How do I learn about new trends on the substantive legal? But then also on the outbound part, where you're kind of telling the world that you exist. Do I have a podcast? Do I do email news? Email newsletters were kind of my jam, and I had a lot of great success with email newsletters. Super easy to do, really fun. You get your name out to thousands and thousands of people. You can add another 1,000 with no extra effort. Very, very easy. So you can use technology both for building up your skills and for telling the world about yourself. But differentiation is really the key, and you can use technology to do that for sure. Absolutely.
I can't. That's just outside of tech generally. I mean, we just went through an exercise where we're looking for a particular type of associate, and we pulled down 70. We pulled down 70 web bios and had to sort through this list. And again, without some way to differentiate yourself, you're just a stack and you're just one piece of paper in that 70. So, I mean, that is an incredible point, not just for legal technology.
I mean, and I would add to that, I think that, every law firm in the country and every lawyer wants to brand themselves as being really great, excellent lawyers and have really great skill. And you all are, right? Like, you're all here in law school. You've clearly been successful in your life. You're all going to graduate. You're all going to be JDs. That's awesome. But I think that you have to figure out how to brand yourself differently, right? What do I bring to the table? And maybe it is your excellent lawyer skills. Maybe it is that you were part of a design thinking clinic and you've really developed ways of looking at situations that clients will really appreciate, right? You're able to unpack what's behind this objection. How can we view this with empathy? What's a solution that might, help all of the stakeholders involved? I never had that in law school. If I had done something like that, I would have been branding the heck out of that, because it's just showing something different you're bringing to the table. It might be something you're passionate about that has nothing to do with the law whatsoever, right? And people they want to buy from people they like. We're all humans. And the more you can be authentic about who you are and what you like and what you bring to the table, I think that's what people want, because we spend more time with our clients and our colleagues than our loved ones, right? So you want to make it an enjoyable experience. For me, I kind of see both sides of this with the technology. I think anytime technology can allow you to do your job, do some of the more rote things of your job more quickly, or scale up your knowledge or expertise, right? Like, okay, I see 5 claims here, but I've run it through AI, and these are 51 potential claims. Now it's going to be on me and my fine think like a lawyer brain to go through and eliminate 43 of these, but here's 2 I never thought of, and I'm going to investigate that a little further. If that helps you get to there faster, I think that's a great thing, right? And I feel like anytime technology can take some of the rote work out of the way for us, you can spend more time on the things that you are passionate about, that you are nerding out on, right, that excite you, then it's just going to allow you to kind of do a better job for your client and feel more fulfilled yourself.
So I'm going to jump in again, just because actually we have a lot of law students in the room, but I see that there are a lot of, I don't know if they're non-lawyers, but they are not so I'm going to ask some questions about that.
Allied professionals.
Allied professionals, exactly. Non-lawyers is a very awful word. So, Augie, let me as I listen to you talk about that, which all makes perfect sense, on the other hand, you have created with Atrium a completely different model of the practice of law that is specifically tied to technology. So can you talk about that a little and how you got there?
Yeah, no, I think the technology is not the technology angle is really good for marketing to startups and for fundraising, but it's not really all that core to the business in a lot of ways. So here's the spiel on Atrium. So Atrium we're a law firm. We're currently serving startups mostly in the San Francisco area. We're actually structured as two entities. So there's a Delaware C corporation which raised $75 million from investors, and then a California LLP, typical law firm structure that houses the lawyers and the sales teams, and things that really need to be under closer lawyer supervision. The two entities are in the same building. We have basically the same name. One is Atrium LLP, the other one is Atrium Legal Technology Services. We are in the same building. We act as a single company. We try culturally to be a single company. We use the two entities for to cordon off the things that need to be cordoned off for regulatory purposes. So we use that to control the flow of client cash, client legal fees, because there are rules around sharing those. And we couldn't have, so there's rules around sharing those, and there's rules around flow of client information. And so we cordon off the fees and the information in the LLP entity, and then have very structured ways of sort of anonymizing data when we need to for the engineers, and dealing with the flow of funds, which is, happy to share more information about that, it just gets a little technical. The key insight behind Atrium is that if you have just a law firm entity, except in the UK and I think in Australia, only lawyers can own that entity. Okay? Only lawyers can own that entity, which means there's nobody you can sell your law firm equity to. Let's say you're a partner in the law firm. There's nobody you can sell your law firm equity to, your law firm partnership ownership to. There's nobody you can sell it to. Okay? And so what that means is that the whole idea of building up the value of that law firm and the idea with the aim of selling it to someone in the future, that whole avenue of building value and realizing value for yourself is not available to you. And so the only way you can realize professional value through doing a good practice and building up your reputation as a law firm. But the only financial value that you can reap from that is through cash that you take off the table every year, which is compounded by the fact that you do have to flush out all the cash every year, because you're an untaxed entity. You're an LLP, so the LLP entity itself doesn't pay tax, which means that any cash that's left in the bank account at the end of the year, this is true for all law firms in the U.S., any cash that's left in the bank account at the end of the fiscal year, the partners pay tax on it, even if it's not distributed out to them. That's really important. Okay, so any money that you might reinvest is post-tax money. Your family has already paid tax on it. Okay? And any potential increase in value in the operations, in the operations of the entity, you cannot realize that increase in value because there's nobody you can sell it to. Okay, so I say it's like being a homeowner in communist Cuba. You have a house, right? You're going to invest a little bit into painting the walls and cooking food and making the place. You have to live there. You make it, and I fill a house with music and good food and love. But you're not going to do the kind of investment into the house that you would do if you could go get a $100,000 home loan, rebuild, and flip it for $500,000, right? You're just not. So you're going to do, as a law firm partner, you're going to spend $10,000 sponsoring a conference. You're going to paint the walls. That's that level of investment. You're not generally going to put millions and millions in. Law firms do sometimes, and that's pretty incredible. But the financial potential to reap financial benefit from that is very, very diminished compared to a corporation. So back to Atrium. The fundamental problem we're solving at Atrium is we're saying we're going to separate out this investor-owned entity, and we're going to take outside investment, $75 million, into that. We're going to build up an operation for the lawyers to practice on, but it's not going to be the practice of law. It's going to be the platform that they practice on. And that's going to grow in value. And then someday that may go public. It may get acquired by one of the larger accounting firms, by Accenture or something like that. Who knows? There are other kinds of providers to companies that are potential acquirers for it. But that's how that's what the problem we're getting at. So back to technology. Bringing technology into the practice of law is not the fundamental mission of Atrium. Fundamental mission of Atrium is making it possible to invest in operational value over time. And if you're going to take that money and invest it in marketing, or take it and invest it in recruiting, or take it and invest it in technology, or take it and invest in training for managers, whatever, that's just a business. That's just a sort of a specific business decision. That's not the core insight, if that makes sense.
So let me just, I'm going to just, as an educator, going to jump in here and just in case people don't know this, there are rules in almost every state, I think every state, that as Augie alluded to, require the profits from legal services or the fees from legal services to only be paid to lawyers. So you can hire somebody, you can hire an engineer to do technology for you, to do, help you deliver legal services, but they're only an employee. They can never be a partner of the business. And so that prevents lawyers from doing some of these creative things. And to do creative things like Augie did, you have to have these workarounds. So my question...
We're not the first to do it. A company called ClearSpire has done it, and then we went through Y Combinator, and there were two other new law firms in our Y Combinator batch too, and another one in the new batch.
So my question first to Patrick and Nick, and then to you and Samina is, if California has a task force on this specific issue right now that is questioning whether that rule that requires profits to stay with lawyers only whether that should be changed, and profits should be able to be split with legal professionals that are not JDs, as opposed to non-lawyers. Yeah, I know, it's so much, yeah.
Civilians.
Anyway, civilians, there you go. Yeah, it is kind of like a military. Anyway, if that happens, what do you see happening with your specific practices?
Yeah, so this is like the crux of what's happening across the country. And there's a number of organizations, including bars like California and Utah. Florida is slipping into this. There's discussions going on around the country among bar leadership and Supreme Courts and some legislatures about how we change this, whether we should change this. Lawyers say, by and large, no, don't change it. We like being protectionist. We like making sure we control our market. The people outside, people who need legal services say, we can't afford you, therefore you can't get to us. We would like that to change. That model needs to change. People like LegalZoom and other companies, right, want to get inside of this legal fold so that law can be dispensed to everyone. So what happens if we change that rule and suddenly we can share fees, right? A lot of people would say, well, suddenly we get access to justice because we can have investors in our small law firms or big law firms or medium-sized law firms. We can bring in other kinds of subject matter experts in, so we can have a marketing expert or a marketing company now part of our law firm, and there's a lot of utopia that comes from doing that. But there are some challenges to it. When you look at UK or Australia, what happened is, rather than finding law being handed out to the greater public and costs coming down, simply the biggest fish ate the biggest fish. And so, like, for example, in the personal injury industry, the insurance companies bought the plaintiff and defense side and now practice law for both sides, but more people don't have access, right? Family law, nothing happened with it. There's one company who's bought up some family law practitioners, but by and large, all the urban or the rural areas don't have any more access than they used to. So this is a challenge about, if we do open it up, is it really going to make a difference other than giving the highest echelon, a greater consolidation, right? That's out there. Challenge. Here's the other challenge among bar leaders, bar presidents, Supreme Courts who are looking down this road is, if we build it, will they come? Is the legal market ever going to be in a place where it's really going to invite in outside companies where there's enough profit to be made? Or is legal never going to be that kind of business? So if you build it, will they come? Utah is very close to creating this alternative business structure environment, right, where anybody can come in. But they say, well, is anybody going to come in or just Utah? All right, what if Utah plus California? Is that going to encourage large corporations to come and invest? Maybe. How many dominoes have to fall before legal is actually being brought into the fold of larger corporations, and Amazon comes in and offers, or Walmart offers law, right? So it's hard to say. It's a big question is if this opens up, what it's going to look like. The best answer I've seen so far is from Utah, who says we're going to create a regulatory sandbox, and we may not get the regulations right, but we're at least going to try them, see what they look like in practice. If we don't get it right, we'll change some rules, we'll change some language until we actually get something that serves the public, invites in outside investment, and grows the practice of law to our democracy.
The Utah example is an interesting one because I was just reading an article about this, and it was hearkening back to when Wyoming first formed the LLC laws. And, every state has now followed suit. But when was the last time any practitioner saw a Wyoming LLC? No one cares. They were the first mover, but there's no first mover advantage here. It's just, to Patrick's point, you need critical mass. So if Delaware falls, if California goes, then yeah, you're going to see this everywhere. But I think one thing that's definitely going to happen, and Patrick alluded to this, is the big fish are going to eat the big fish. We'll go public. Kirkland's going to go public. Mayor Orrick, all the big guys are going to go public. There's no question about that because the partners will be drawn to the capital that will follow that. As to the access to justice point, I actually could see it changing because of things like LegalZoom that are prevented right now from rendering legal advice. Right now, you can only print a form. But if LegalZoom could hire a bunch of cheap lawyers and you could suddenly render legal advice online by this large, well-backed company, I could see a material change in the access to justice space. So.
On the big fish point, I would say there actually are no big fish in legal. Mm-hmm. Companies spend about $150 billion a year on law firms, and the largest law firms are do about $3 billion in revenue. That's like 1.5%. Yeah. Of the market share. Of the market share. 4.
The biggest players in the legal.
Oh, they get up to like $4 billion.
4%.
4.
Of the revenue.
Like the top 10 represent 4. Top 4.
Right. All the big firms together only represent 4%.
What's all the big firms like 10 or 100 or 200 or?
The list I was looking at only had about 4, but I'm not.
Okay. Yeah. That makes sense. Yes. Yeah. So it's extremely fragmented.
I think one thing interesting that could happen, I've talked to a lot of general counsel and chief legal officers, in-house, who say that the people they most like to work with inside law firms are generally not the relationship partners, right? It's the KM folks, right? The knowledge management folks. It's the legal project management folks. It's the tech folks. It's the folks who are really focused on the chief client value officers, the folks who are focused on, I think, that delivery of legal service, right? Every law firm in the world is just still branding themselves on their excellent subject matter expertise. But, I use Uber Eats and I use Postmates because they bring the food to me and I don't even have to talk to a human to get it. And there's some nights I just don't want to talk to a human, right? And so, and I've heard a general counsel say, like, the counsel I use outside the most often are the ones who know whatever they hand me, I have to turn and translate into something my business owners can understand. So I don't want a 12-page single-spaced memo that says it depends because I can't give that answer, right? And you guys all know really well how to do that now, I know. But, and even the outside counsel will give it to me in PowerPoint form, right? And so I think that if removing that bar on, lawyer ownership versus other folks allows law firms to make more space at the table and truly compensate people who will help bring efficiency and value and transparency, in a way that people have had to create really complicated structures to incentivize and prioritize that right now. I think that's a good thing. I know there's dangers and risks there that I'm probably not thinking through, but I feel like more competition in this arena that might allow for, different behaviors to be incentivized and motivated in folks is not necessarily a bad thing.
The problem with the Uber Eats example, though, is because you order from Uber Eats when you primarily want convenience.
Yeah.
And you don't hire Kirkland Ellis when you primarily want an easy interface. It's like you don't pick your brain surgeon because they have a nice bedside manner. Like, you pick your family doctor because they have a nice bedside manner. Someone you want to call up, someone who answers your call, someone who's nice to talk to.
Yeah, but you're not having brain surgery every day, right? There's
That's
a lot of other things things you need.
That's exactly my point. So you just need to ask yourself, like, what does the customer want in that? What are they looking for in that? So I think it's a mistake in general. There's a lot of negativity around. There's a lot of kind of anti-lawyer negativity out in the market, which law students are also aware of, I'm sure, and I think that it comes from not looking at from looking at kind of all the situations and kind of use cases in kind of the same bucket and kind of the same situation. And as a practitioner, you really want, this kind of comes back to this point about like not just going for the A+ on the same test that everybody else is being tested on. You really want to think about what kind of a client you want to be providing, what type of clients problems do you want to specialize in, and make the habit of asking yourself over and over and over throughout the course of your career, what would make me better able to solve this client's problems? And if what you want to be doing is arguing novel cases at the Supreme Court or at an appellate court or something like that, then the emphasis is really for you as a practitioner on those core legal skills. Or if you want to be dealing with the kind of the bet the company cases or something, you need to figure out how to position yourself so that you're seen as the expert for those cases where the companies really just all they care about is winning or not losing, and they don't care as much about the kind of the delivery form factor or the price or something like that. There's a whole segment of the legal market that is almost entirely immune from price competition. A huge section of the legal market that's immune from price. Reducing costs is not a primary concern for many practitioners out there because they're competing on expertise, because they're competing on the ability to solve novel problems that other people can't solve. And I would just want to emphasize to law students, because it's very easy to lose sight of this, that the way you get yourself to a position where you are the vendor of something unique is not by doing the same thing that everybody else is doing it, but just doing it better, faster, stronger, cheaper. It's finding something unique to offer to the market. And the range of things that people need help on is growing and growing faster and faster. And the more the economy develops, the more opportunities there are to find niche practices where you can be one of a very small handful of experts on something where you have much more leverage in setting the terms on which you work, on which for your clients, where you work for your law firm, the way you work, all these kinds of things. So I just want to kind of little pull here for the kind of the traditional view of lawyering. If you can, this can be an expertise profession, and you can compete on expertise. You just need to be focused on seeking out that type of client and that type of matter to be an expert on.
I just want to add another layer to this. It really depends on who your market is. It really does. I would challenge all of you, if you go into practice, not to say, how can I charge more? But to say, how can I charge less? How can I use innovation? How can I change business models? How can I give more service easily, more accessibly to more people by charging less? The LegalZoom model isn't charging more. It's coming under the market where lawyers can't go and taking over the entire arena of people who can afford LegalZoom, and then eating their way up the chain until all that's left is the very top of the pyramid of big firm litigators that are very have a lot of expertise in a very small area, just exactly what you're talking about, where they live very, very well. But there's the whole rest of the pyramid out there, which is most of the country, who desperately needs legal services. So it really depends on what market. And you are spot on for the market you're talking about. But for the rest of America and the working class and those people who need legal services, the question you need to ask as you come out is, how can I charge less? How can I be that innovative lawyer to change the paradigm, to change the model, and to offer legal services to people who need it the most? Not the biggest fish fighting the biggest issues in business. That's a need and very, very important. But the rest of the country needs us to fill in that huge gap that's not being met by lawyers.
We'll get back to my interview in just a moment, but first, let's take a break to hear from the sponsors who generously support Law Next. And now, let's continue this week's interview.
So I just want to point one thing out. What I think is so different about everybody sitting here that you wouldn't have heard 20 years ago is that you're all talking about what does the customer want? What service should I provide, as opposed to these are the services I offer. If you can pay me, I'll do them for you. And I think that is the way, and that is the viewpoint that will ultimately change the practice of law, is by focusing on the customer. And so I don't think most lawyers are there yet. but I think, you guys are leading the way here, and I hope all of you guys who are out there who will be practicing law will be leading the way. The rest of the world has come to that. And when some practitioners say to me, look how great we're making so much money, look how great it is. My answer is yeah. And the taxi industry thought that too in 2007, and look what happened to them. So with that being said, I am going to open it up to questions, and then maybe at the very end we can have summing up from all of you. But if anybody has a question, please stand up. We'll get you a microphone. I'll give you a microphone. Does Rebecca have one? So we would like to record all the questions and the answers as well. So we're going to have to share that up here, I guess, for the answers. I don't know.
Hey, appreciate the insight on all of you. Jason Velez, my company's One Law. Kudos to Augie. I appreciate the transparency. Big fan of Atrium. I can tell you a little disheartened as a technologist in the space that's actually out there trying to sell legal tech. And then when I saw it and everybody asked, there's this magic bullet that Atrium created and raised all this money on. And instead of just saying, if Latham and Watkins decides to divert 10% of their $3.5 billion, they're an overnight unicorn. But the question is, on the revenue model, how much would be couched as traditional legal services before the platform fee kicks in?
Almost all of our revenue is service revenue, and will probably be that way for 5 or 10 years.
But that is the arc, though, the 5 or 10 years, and then because I do believe the platform will eventually, take over to some extent.
A lot there that's kind of remains to be seen.
Fair enough.
Hi. So
We don't know. Yeah, we don't know.
Page memo, depends.
Yeah, I will say this about the tech. One thing that we've really learned is that I think we kind of knew in the back of our heads that we weren't going to build software that was going to magically make all of our lawyers 50% more efficient. That's just not.
Go back to the VC community.
Yeah.
That's the feedback I'm getting.
It'd be interesting to talk about your specific company. Happy to talk about that. But you can also think about the software as doing other things. You can think about it as adding value, either increasing your ability to advise, as Nick was saying, or in terms of ability to tell the world that you exist. For example, we early on we spoke with Crunchbase. I don't know if people are familiar with Crunchbase. It's sort of a database of all the companies that get funded, and they publish an API so that you can pull data from their database on all the different companies that are getting funded. And we thought, well, this will be interesting. Let's look at every company that has raised at least $200,000, and let's cross-reference that against Glassdoor, and we can see who's hiring. Okay, so we can see every company that got a little seed funding, and then we can see which companies are hiring quickly, are ramping hiring. Those are ones that are probably going to raise money soon, and let's go out and market to them. That's kind of a day one idea. And we reached out, we spoke with Crunchbase, and they said we were the first law firm that had reached out to them. No law firm had contacted them about getting access to their database, which just get pretty interesting. That's not an efficiency thing. That's not a productivity thing. That was purely sales and marketing. So that's one way that you can use it. Another way you can use technology is you can use it to provide ongoing value to a client. So you're providing value to them continuously, not just when you're on the phone or writing an email or drafting a document for them. So, for example, putting out a dashboard that helps them keep track of the status of all the different things that you're doing for them, for example. That's something that Atrium clients pay a subscription fee every month, just so whether they use it or not. Mm-hmm. And then if we see that they haven't come onto this dashboard that they're paying for, we either take that as the dashboard maybe is not as useful to them as we would hope, or maybe they're going through, maybe it's time to reach out to them and kind of reactivate them to use sort of a consumer web kind of lingo. But you can use the software for all different kinds of things, not just the efficiency point. And so when I say we're kind of seeing where things are, we don't really know where the roadmap is going, is that we're kind of discovering new ways of using software and developing software that are different from just kind of saving time collecting signatures or saving time drafting documents or things like that.
Hi. So I'm Jennifer McGlone. I'm the Director of Legal Affairs at CourtBuddy. We just closed our Series A. We're a legal tech startup based here in San Francisco. And
congratulations.
Thank you. I'm excited. I closed down my own private practice of 20 years to come on board, so I'm very excited about the company. So one of the things that we're trying to do, our main thing that we're trying to do, I'm looking right at you, is we are trying to help solo and small firm lawyers access the huge middle class market for legal services. It really is a huge market. It's 65 million people a year go into court unrepresented. That's huge. We only have 1.4 million lawyers in the U.S., so think about that. Every lawyer has 48 clients they could have a year. So what we're trying to do is we're trying to leverage technology to take some of the pain points away from getting real lawyers to work with clients, as opposed to go on and do a LegalZoom or Rocket Lawyer where you pull a form off of the internet. We're trying to connect real people with real lawyers, thinking that real lawyers are going to give the best service. But we are definitely seeing that the law is a closed profession, and there's a lot of ethics rules on the books that are troubling and problematic, and that we have to carefully navigate when we try to match our lawyers with our clients. And so my question is, which way will California go? Is California going to go the way of Utah? Like, how do you think the trend is really playing out? Do lawyers want to find the middle class consumer? Are the bar associations going to open up and revisit some of these rules, or is there going to be a movement towards greater and greater protectionism?
Yeah, there's a big dynamic there if you haven't figured this out in this conversation, right? Lawyers, and not all lawyers, but there's a lot in the rank and file that want to keep this industry and the monopoly intact. Do not open our markets. Do not make us decrease our costs. We want to hold on to what we've had for 100 years. And there's the other group that says, no, it is time to expand, and there's a huge market that's untapped, and if we don't jump out there and get it, we're going to lose it to outside organizations like LegalZoom and Rocket Lawyer. And so here's this tension on both sides, right? The rules are going to change. They're already changing. There are so many organizations working on them, and splitting fees, sharing fees is going to change. Question is, who goes first? California? Maybe. I think that task force is making some real headway down that road, and with a legislature and a Supreme Court who wants to see it happen because they don't see protectionism as being the way to offer legal services. There's nothing good coming from that direction. So they may. Utah's going down that same process. I think it's going to happen. The question, I think the fear that a lot of people has is, if it happens, again, will they come? Is there a market there that will bring people in to do it? You make these huge transitions into opening up the market for people, and then no one comes into the space. It'd be a disaster, because all the other states would then say, we're not going to do that, right? It's got to be a national process that does this, I think, to really make the market respond to get in there, and that will affect you greatly in a very positive way.
So you're saying that there's actual real doubt about, if you open the markets, whether investors would enter the legal market, that's like something people really doubt?
Yeah, that's a big part of the discussion, whether that market will really come to fruition. Other than, as we said earlier, the big guys eating big guys, whether that market to the trillion or 300 billion latent market of people who need legal service, well, that will ever be serviced. Well, whether the businesses will come into that market.
Well, I hear two separate issues. One is, would opening the market solve all the problems? And I think clearly not. That's separate from, if we open the market, will a lot of people enter it? And I would be surprised if there's a strong voice out there doubting whether people would enter the market. What?
When you say enter, you mean the venture capitalists, the investors?
Any non-civilians.
There's one more piece to this, though, which is what size is your market? Is California big enough to have companies come in? Is Utah in itself big enough? I think it's clear, if we open up the entire country, it's going to happen. But when you have individual markets like that, and everybody's looking at that market under the microscope and see what's going to happen, that's where the fear is. Because someone's got to be the first domino, and if that domino is not successful, then we're going to kill a whole idea that's critical to our success and survival.
What I wanted to ask is, what's the best argument? What's the best argument you've heard for why investors may not enter the market? It may just be that a particular market may be too small to be worth their while. Okay, fair enough. No problem on that. Other than that, it seems pretty far-fetched to think that people would not pursue the opportunity.
So when you say people, a business coming into it, are you thinking like H&R Block for taxes will now be H&R Block for law, that there will be there'll be companies, but they're offering with lawyers working at it? Yeah, like the Big Four. Okay, I didn't get to. Okay.
Okay, I'm Paul Wolonik. I'm a professor here as well and director of the Startup Legal Garage. I want to explore a tension that maybe we haven't talked about yet, which is law firms, especially with the profits per partner model, in some ways thrive on inefficiency. And not only do they thrive on inefficiency somewhat, but they also get sort of a benefit because the more profits per partner you have, the more there's kind of a luxury buy. I remember when I worked at a large law firm, a lot of people would say, you can't go undercut this market because GCs want to pay top dollar so they can tell their CEO, hey, if we lose, at least we paid top dollar so you know you got the best you could get. Is there an inherent tension there, and how do you see that playing in with technology?
I think that the pedigree issue you described with high profits per partner still exists, but on a much lesser scale. That is for more bet the company litigation, bet the company transaction type work. That's where you need to justify, hey, we had to hire Wachtell, right? That still exists, but it's gone down quite significantly because there's a lot more tension of why are we paying Sidley this much for this transaction? Why are we paying this much for this basket of services every year in and out? And so, while yes, we are incentivized by the dollars per hour rate, we're also getting significant pressure from our clients to reduce the amount we bill. And that's what we see. A lot of our work comes in through huge RFPs that come in, every year. And every time we have to respond to an RFP, we can never raise our rates. We can't charge more. Same basket of services, we have to come down. And our competitors are all in the same boat. So everyone's coming down. And so it's not a race to the bottom, but it's a race to do more with less. And that's where technology comes in, because it enables us to do more faster. But it also enables an interesting spin, which we found is that instead of charging the same thing, let's say we think this will take 10 hours at $500 an hour, we'll charge you $5,000. If with technology we could do it in 5 hours and $500 of technology cost, so the net cost is $3,000, we may still bill it at $5,000 and pick up the $2,000 in the delta. So there's still a tremendous opportunity for profit by leveraging the technology correctly.
Yeah, and I think it also goes to that, as you do things, you should be getting faster at it. And you should be able to, leverage your past experience doing it. But I think part of the problem is most law firms have their data and information sitting in like 89 or 600 different systems. So they've really had no good way to tap into other than, well, our seasoned partner, Nick, in his experience says it'll take this much. Let me put my finger in the air. Let me figure out, okay, yeah, this is what I'm billing this RFP at. And so for me, I think technology is one of the great tools that will allow law firms or providers, whoever they are, to give more transparency and clarity around making those decisions, right? And saying, hey, 70% of the cases we've seen have settled within this many days after this motion was denied. So kind of allowing it to get cheaper each time because you have no choice, but also hopefully allowing the firm to provide some other services to those clients, right? I mean, I think it's not a surprise to anybody that the Big Four are taking some market share right now because they're not out there saying, well, we're now going to march into the legal market and provide legal services. They're like, hey, you're our clients and we are providing you all of these services and all this advice. And now we happen to be providing you solutions that contain a legal context to it. We're not trying to be your lawyers, but you're already our client and we're gonna cross-sell just like every other law firm out there is gonna try to cross-sell you,
Can I say, reiterate back what I hear your question is and then have fun with it? Okay, so I think what you're saying is, isn't there this inherent tension between the kind of profits per partner as a kind of a business model and the sort of mandate to innovate? Isn't there a tension there?
Sort of. In other words, the clients are saying, I would like to pay less, use innovation to help us pay less. But the partners are all saying, if we drop revenue, we're going to actually drop rankings. AmLaw is going to look cross at us and all this kind of stuff. People aren't going to cross over to join us. Profits per partners low, we're not going to get laterals, all kinds of things that go down. Is that the inherent tension? And how does that
Got it. Cool. I don't think so. And I'll say why I don't think so. Profits per partner is extremely important and will always be important. Just as important as profitability or earnings per share is important for every other money-making business. There's no way that less profitability is going to be better or should be seen as better or that should be embraced, ever. Just as far as running a healthy business, for all the reasons you said, attracting good talent, reinvesting in operations, there's no world where not caring about profits per partner is better, unless you're switching to just a better metric of the type of profitability you care about, like profits per lawyer or profits per employee or something like that. But some kind of profitability measure is, if you do away with that, you're not doing business anymore, period. Okay. However, I do think that there is an inherent tension. I think this is, I have to attribute this to a new friend of mine, Jay who's Director of Strategic Pricing at Pricing Strategy at Baker McKinsey. Her articulation of this is, I think, very concise and take a little bit to unpack. I'm going to give you the concise version and then unpack it. And I think this is a concept to carry with you your whole careers. Okay, this is one of these fundamental insights. The concise statement of it is that until you decouple pricing from compensation, you cannot improve your business. You cannot dramatically improve your business. Okay, that's the concise version. I'm going to unpack it. Concise version one more time. Until you decouple pricing from compensation, you cannot materially improve your business model. I'm just going to explain what that means. Pricing for most firms is based on number of hours worked, unless you're doing some kind of like contingency fee thing, or I don't know if I haven't been, some kind of alternative fee arrangement. You're going to be, unless you're on an alternative fee, some kind of fixed fee arrangement, you're going to be billing in terms of numbers of hours worked. That's the pricing part. The compensation part is, at most firms, and I would be very curious, I think this is true even at firms where most of the work is on a fixed fee or alternative fee arrangement. Compensation, in other words, how lawyers' contributions are evaluated are primarily evaluated in terms of volume of work. Volume of work, the billable number of hours they do. And I'd be very curious if when you're on an alternative fee arrangement, if kind of like the associate working on the FA is not evaluated in terms of the number of hours.
Hours, really.
Yeah,
a whole bunch of
there's a bunch of very curious to see how other firms many firms have, each firm takes a different kind of approach to this. But I want you to internalize this one concept. As long as the amount of money that you're bringing in, your revenue, is primarily predicted by the number of hours worked, and the behavior that you're rewarding among your employees, your lawyers and paralegals, is primarily influenced by the volume of work they do, then you can increase, as long as those two are coupled together, then as revenue grows, costs grow. As revenue grows, costs grow. What you want as a business is you want revenue to grow and you want costs to go down. Or you want revenue to grow faster than costs. You want this delta to grow over time. And if that's not growing over time, not only would investors, for example, not invest in you, but that's using more of a corporate way of thinking. Even within a law firm, if you're out recruiting, telling a partner, you should come here, you should bring your expertise here, because we're getting better and better each day. You can't say that. You can't say we're getting better and better each day, materially better in terms as a business. And so as long as these two are coupled together, you're forever locked into this thing of the more you grow revenue, the more your costs grow, and you don't improve it, you don't become more powerful as a business. And if you plot out law firms with like an x-axis of number of lawyers and a y-axis as profitability, the most profitable law firms tend to be a little bit smaller, and they do not get more profitable as they get bigger, which is unlike most companies which decouple pricing from compensation or pricing from costs. In law firm world, your main cost is compensation. So that's the key thing that you want to look at is can you drive up cost? Can you drive up revenue with keeping costs at the same or going down? That's the idea. And so back to this point. Sorry if I'm hogging the time here, but going back to this point, yes, as long as I don't think it's profits per part. You do need profitability measures. You always need profitability measures. But as long as your costs rise lockstep with your revenue, then you do have a tension. Yeah, and you do have a tension.
Well, I'm sorry, we have to bring this to a close. Everybody I know has other things to do in their busy days, and we would hope our panelists will stay around for a little bit. If you have questions, you can come up and talk to them individually. But right now, I'd like to really give them a round of applause for a really interesting discussion.